Hi, my name is Lisa Cummings, and today I would like to share some information with you about qualified domestic relations orders and survivor benefits. The importance of survivor benefits being included and addressed within a QDRO will help protect your future income. Before I start with the discussion regarding survivor benefits, I first wanted to share with you a little bit of information about our firm. Our firm's website is www.cummings.law, and we service both businesses as well as individuals for many of their legal needs. I have worked individually with folks planning their retirement as well as specifically assisting individuals and large corporations regarding retirement benefit plans and qualified domestic relations orders, as well as additional legal work in the areas of compensation and benefits and even executive compensation. But today I want to talk with you about my expertise in the area of dividing retirement benefits in the event of a divorce. So let's talk a little bit about qualified domestic relations order and how the survivor benefits should be treated or addressed within that qualified domestic relations order. One of the most overlooked but critical aspects of a qualified domestic relations order is the treatment of survivor benefits. In a divorce, spouses often will focus on dividing their account balances or monthly pension payments without considering what happens if the plan participant was to die first. Unless the survivor benefits are addressed in the QDRO of a pension plan, the alternate payee may lose income they're counting on for retirement. Pension plans and other types of annuities. So specifically, I'm now discussing qualified domestic relations orders for pension plans. In a defined benefit pension plan, survivor benefits typically take the form of a qualified joint and survivor annuity or a qualified pre-retirement survivor annuity. These benefits ensure that payments continue to a surviving spouse after the participant's death. For divorcing spouses, a QDRO can secure these rights for the former spouse, but only if the order explicitly provides for them. Without this protection, if the participant dies before or after retirement, payments may stop, leaving the alternate payee with nothing. QDROs for pension plans must address survivor benefits. A common pitfall arises when survivor benefits are not addressed until after the participant has retired. At that point, many pension plans lock in the benefit elections, and a former spouse may be permanently excluded. For this reason, it is essential to address survivor benefits at the time of the divorce and secure them through the QDRO before the participant makes the retirement elections. QDROs for 401k plans work very differently. Defined contribution plans, such as a 401k plan, operate differently from pension plans. Because these 401k plans hold a liquid account balance, there are no additional traditional survivor annuities. However, it is important still for that QDRO to clarify how death benefits will be handled. For example, if the participant dies before the QDRO is implemented, the alternate payee may have no rights unless the order is already in place. A well-drafted QDRO ensures that the alternate payee's share is preserved even after the participant passes away. Next steps for dividing a pension during a divorce. Anyone dividing a pension through a qualified domestic relations order should insist on addressing survivor benefits as part of the order. The QDRO must clearly specify the alternate payee's entitlement to either a survivor benefit or a share of the death payments. Consulting with an attorney experienced in retirement plan law is essential to avoid drafting errors and to ensure that these future protections are locked in before retirement or remarriage alters the landscape. For more information, please visit our firm's site at www.qdro.law or send me an email to lisa@cummings.law. Thank you for joining us today and have a great day.